So here's the thing, there was Coventry had a Hawaiian barbecue.
Good.
Not a big fan of Hawaiian, it's like too sweet. But the way they smoke the meats.
I'm gonna begin the meeting as well.
Amazing.
Minute.
I want to go to the Indian place.
That's good.
Or sooner. Okay, we have a public hearing tonight. The council is reviewing a draft proposal for a short-term rental ordinance, STR, and seeking public comment.
Do we want to do the motion from?
Oh, I do. Thank you for that. Right. Thank you very much. I want to take a vote to seal the minutes of executive session.
No move.
Second,
Second.
all in favor?
Aye.
No votes were taken in executive session. I am going to make a motion now in open session to direct the solicitor to act in accordance with what was discussed in executive session.
Second.
All in favor?
Aye.
Thank you, Andrew. We have a public hearing tonight. The council is reviewing a draft proposal for a short-term rental STR ordinance and seeking public comment on the proposal. So this is the public's time to speak to the council on how they feel about this ordinance. And we will sit here and we will listen to that intently. I just ask you to make it as brief as you can. And if you want to approach or just raise your hand and we'll have you come up. I see a hand on the left. Jonathan Gabriel, IT Director, would you like to say something?
Yes, Mr. President. I think I was the chair, I was the secretary of the committee, and I think it'd be helpful if I made a statement.
On the obviously on the STR. Is that okay with the council? Any objection to that? Okay, Jonathan, you've got your 3 minutes.
We hope your mic works.
Hope your mic works. Thank you.
Just some copies of my sort of summary of our findings are available in the back if you follow along that on the way in. We have a short-term rental advisory committee established, and we would have to do the people that short-term rental ordinance and this body with a recommendation. The draft in question is based on work previously done by the planning board. We would like to acknowledge and thank them for all the hard work that's gone into this day together.
That's a good point. So the planning board had this twice now, and this will be our third public hearing. So I do thank the planning board for, since 2022, I think.
There's been a lot of input and feedback from many years. The committee consisted of Victoria Talbot, Denise Cosgrove, myself, and Richard Petrin, the fire chief, as town representatives of various departments. Also resident and chair of the Harbor Commission here, Kristen Silvera and Mike Russo, who are both residents in town, but also property managers and owners of multiple short-term properties here in Little Compton. So we especially want to call out big thanks to them as having their input valuable in this process. Community stakeholders, the town officials, representatives from the Rhode Island League of Cities and Towns, HOA and neighborhood representatives, realtors and property managers were invited to attend, as well as or very own solicitor. Other methods of feedback. We reviewed many other comparable municipal ordinances as well. All of that stakeholder input considered, there are many varying opinions on how short-term rental should be. But one thing that was common among all input is that repeatedly cited the lack of local data on short-term rental prevalence, impacts, and effects that it make this process. We wanted the rationale for a registration system so we can establish a baseline to understand the data. The state registration as it exists is largely inadequate in many purposes, and we can capture enough information to provide for our town. We also don't have access to most. Based on this knowledge, key changes we incorporated into the planning board's prior draft includes further defining the registration process to make it as simple as possible, cost neutral to the town, and place an emphasis on public awareness and education and clear owner obligations. We removed inspections as a prerequisite. We scaled back rigid verification requirements in favor of affidavits during the registration form. And we recommended a flat fee with a discount, but for those that qualify for the homestead exemption. And for our resident population. This also includes a grace period for the start of registrations, ensuring everything has time to come to compliance and is aware of. All in all, the final recommendation is to establish a registration system now to build a reliable data set so future decisions are evidence-based rather than reactive. This is not a permit. This proposal is not allowing or denying activity on any property or putting restrictions in place outside of what exists in pre-existing municipal code or state law. This is a registration process. Proposed to gather data so that the town can make informed decisions. Take action if it's necessary, but if it's not, I'm sure the rental in the future.
Thank you, Jonathan. I'm going to consider you the public. Anyone else would like to speak? That would be the time. I have a hand on the right, Kristen Silvera, come on up. I think if anyone listened to Jonathan, Kristen was on this committee, and we thank you, STR and manager in Little Compton.
Hello, yeah, this is Sarah, 16 Old Main Road, Little Compton. First, I did want to thank Victoria for reaching out and including me on the committee. I appreciated being part of the conversation and being involved in all the meetings, but I do continue to oppose the ordinance as it stands. I feel it's redundant and unnecessary, as short-term rentals already must be registered at the state. We have been residents of Little Compton, my family and I, for 24 years, and vacation rental home owners for about 15. While platforms like Airbnb may feel like make vacation rentals feel new, the reality is that summers in Little Compton have always involved visitors renting homes to enjoy our town. They were part of our community for centuries. As Sarah Sol Wilbur wrote in her journal on August 24th, 1890, every house is full of visitors and boarders, all trying to have a good time. There has been discussion suggesting that short-term rentals are causing housing affordability issues. In reality, vacation rentals are less than 5% of the housing in Little Compton. The 2020 census shows that 38% of our homes are seasonal. Only 12% of these are being used as a vacation rental. We have an aging population. Older homeowners are less likely to move. We have 2-acre zoning, and most large lots and farmland are purchased by the Land Trust and Secana Preservation Association to preserve open space. There are over 4,000 acres of preserved land in Little Compton. This is almost 25% of the town's land. These factors, not the 112 vacation rental homes, are the real drivers of housing affordability challenges. Some have raised concerns about unregistered vacation rentals bypassing state registration. In reality, all legitimate platforms like Airbnb and VRBO require state registration. Obscure websites are either connected to these platforms or too minor to matter. And let's be honest, anyone bypassing the state's registration would not comply with the town registration either. The information the town seeks owners to provide, owner identity, property management, number of bedrooms, septic capacity, state registration number, is publicly available information and available to the town if they have the need to investigate a particular property. It is my opinion that this duplicate registration is unnecessary and a waste of the town's money. What about enforcement concerns? Police report very few issues, maybe 1 or 2 noise complaints last summer, both resolved immediately. Fire and building officials see no vacation rental related problems, and none of these departments feel the need to enforce this additional ordinance. Existing town ordinances already do exist for parking and noise, with very strict rules, fines, and enforcement tools in place. Community outreach also showed minimal concern. As Jonathan mentioned, we reached out to representatives for the town, and nobody felt the desire to come to one of the meetings to express their concern. Septic systems have been mentioned as a concern, especially cesspools. The building official reports only a handful of these problematic systems, and he does not see this as an issue. The vacation rental season here in Little Compton is very short, just a couple months. So that means there is little to no use of the septic system for the majority of the year. Again, as Jonathan mentioned, the committee invited the executive director of the League of Cities and Towns to attend the meeting. And he stated that the only benefit for a town to adopt an ordinance would be to impose additional restrictions because everybody already has to register with the state. Only 14 towns in Rhode Island have chosen to adopt their own ordinance. The proposed annual fee of $250 is 10 times the state registration fee, which to me feels excessive. I have concerns this fee would open the town to litigation. Rhode Island law states the municipality may charge a reasonable fee not to exceed the actual costs incurred by the town. I also have concerns that the discount for the homestead exemption may violate the US Constitution's norm of commerce clause, which states municipalities may not favor their own residents by burdening people from other states. Legal precedent is also a concern. Many local ordinances have faced legal challenges. In Narragansett, a judge issued a temporary restraining order and halted enforcement of their ordinance. The court reasoned that their ordinance conflicted with the state law protecting an owner's ability to advertise their short-term rental. The proposed Little Compton ordinance contains language similar to Narragansett's, which could create legal exposure. Phrases like preserve the character of the community and obtain information on STR activity are considered legal red flags in policy information language. Additionally, language about minimizing neighborhood disruption frames short-term rentals as commercial or hotel-like, implying incompatibility with residential use. The state explicitly chose not to classify short-term rentals as hotels to distinguish private property rentals from commercial lodging, making this framing particularly risky. The most legally vulnerable part of the ordinance is the last sentence in the statement of purpose, to collect data and evaluate their effect on housing affordability and community stability. Courts often interpret this as signaling as an intent to impose future regulations, which could be seen as an attempt to circumvent state policy. In conclusion, the evidence shows vacation rentals are not causing problems in Little Compton. Current registrations already address potential issues such as noise and parking, and that according to the police chief is not actually an issue. And the proposed ordinance fees and language may expose the town to unnecessary legal risk. Thank you for your time and consideration. Again, a lot of time on the planning board, which I understand, and I urge the council to carefully weigh whether this ordinance is necessary and enforceable before moving forward. Thank you.
Thank you. Do I see another hand? I see a hand. Remember to state your name and address, please.
Yes, I'm Tom, 173 John Dyer Road. I'd be reading from papers that my printer wasn't cooperative.
Can he speak into the mic? Because people are commenting at home that they can't hear.
Just lean into the mic a little bit more.
So as we have ongoing issues, we get texts, you're getting some text now, right? Speaking into the microphone because people at home cannot hear.
Okay.
That's why I speak into the mic.
So, state my name. I will again, Tom Clement, 173 John Dyer Road. 2 weeks ago, the town council accepted purposes for a short-term rental policy. There were a number of reasons, but I'll just, without reading them, I want to point out just one of those stated purposes. It's the second one. It is ensuring short-term owners are aware of health and safety regulations, good neighbor practices, and state and local ordinances that help ensure that the owners and operators act responsibly towards their neighbors, the environment, and the local groundwater. I agree with the principles and purposes that were accepted 2 weeks ago. I attended one of the short-term rental meetings from the ad hoc, and I support this and these purposes. And also concur with Jonathan that we don't really know what we have. We have a state database, but we really don't know what we have for rentals of our properties in town. And so registration will help inform you, the town council, and our town members as to what are the effects of short-term rentals, which have been increasing on the year-round stock. So I only want to address that second item, in particular related to groundwater. Because groundwater is valuable town resource. And for that purpose, the draft policy specifies that occupancy should not exceed the bedroom capacity of the septic system. If you know the short-term rental ordinances that other towns have used, this is a key thing in every one of them, that you can't overload a septic system with too many occupants. Under the current draft, the owner is required to report the bedroom capacity of the septic system, assuming that the owner checked and reported the accurate bedroom number limit in the DEM on-site wastewater treatment system permit database. Here's a real scenario. An owner might think, if having bought a 4-bedroom house, then you would have a 4-bedroom septic system. Perhaps confirmed by looking at the assessor's database properties. It says, okay, you have a 4-bedroom house and you're taxed for. Here's my circumstance. I bought a 4-bedroom house. I thought I had a 4-bedroom septic system. After I was informed how to look into the DEM database, I saw I have a 3-bedroom septic system. So I think it is very important that renters check that database and identify how many bedrooms the septic system is designed for. Because you just have a lot of water use that exceeds the septic capacity. And even though maybe properties are rented primarily just for the summer, who knows what can happen if you overload the septic system. The current draft policy by test attestation or affidavit, I think says, just tell us how many bedrooms your septic system is. I would like to make a change to the draft that specifies the owner identify the database ID for the septic system and how many bedrooms are specified in that record. This will mean that when a homeowner does a declaration for the registration, the data will be tighter and we have a better assurance that indeed the homeowner did check the database record and is appropriately reporting the number of bedrooms. So to protect the integrity of the groundwater, the town should have reasonable assurances that the owner has appropriately checked the septic permit and accurately reported the bedrooms in the septic record, specific record. This will protect the property owner from unknowingly overloading their own septic system over short term with an unsafe number of occupants. And also to protect the safety of the homeowners and the nearby wells. I have no other safety recommendations for the short term rental. I ask that this change be made to add homeowner identification of the permit number in the database. Thank you.
Thank you. I have a hand in the back. And it's you. I'll have this time when you're walking up, state your name and talk close to that microphone.
Hi, my name is Kaz McGinnis and I've been a full-time resident in Compton for over a decade. Thank you for the opportunity to speak. I'd like to put forward some legal concerns on record regarding draft short-term rental ordinance. These concerns relate to necessity, national basis, and unequal treatment. Objective 1 is identifying STR operators. As Kristen pointed out, we are already required to register with the state, and that register is accessible to the town. Furthermore, using the database, the town already sends STR as tangible personal tax forms, and it collects the business taxes in addition to the property taxes. So STR operators are therefore already known, identified, and regulated. A separate local registration does not advance stated objective and appears duplicative and unnecessary. Regulations that duplicate existing systems without having a legitimate governmental function raise concerns of arbitrariness and lack of rational basis. Objective 2 is minimising disruption and ensuring safety and good neighbour practices. This objective singles out STR owners and renters as requiring special instruction in safety, responsible behaviour and neighbour relations. No such requirements apply to other homeowners or other home-based businesses. Many STR renters in this community are not transient, but individuals with family ties to the area, often staying locally because relatives lack space to host them. Town-wide safety and nuisance laws already apply to everyone. Singling out STRs without evidence of unique risk raises equal protection and uniformity concerns. I'd like to pause on this point to refute some common assumptions about short-term rentals. Concerns that STRs generate more trash are overstated. All STRs have vacancy periods, though total trash is less than a full-time household. Additionally, these people are on vacation and they get many meals eaten at restaurants. 2, concerns about traffic and parking are exaggerated. Most STR guests arrive as families or small groups in 1 or 2 vehicles, comparable to permanent households. 3, the assumption that STRs host frequent parties is inaccurate. Most stays involve family visits, holidays, and personal gatherings, not commercial events. In any case, rental platforms and house rules already forbid parties and gatherings. The notion that renters are unfamiliar or indifferent to local norms ignores that many guests, as I pointed out, existing family and community ties to the area. These assumptions should not justify singling out STRs, especially when other residential or home-based uses with similar or greater impacts are not regulated in the same way. Now to objective 3, housing impacts and nuisance prevention. The premise that STRs require special regulation to, quote, prevent nuisances assumes that STRs are inherently a nuisance without evidence. Other home-based businesses, such as plumbing or contracting operations with truck traffic on residential streets, clearly impact neighbourhoods, but are not required to register, submit parking plans, pay special fees, or face special enforcement. Selective regulation of STRs constitutes discriminatory treatment of similarly situated uses. A lack of legal justification. To lawfully enact a new ordinance, the town must demonstrate a legitimate governmental interest and a reasonable relationship between that interest and the regulation. The stated objectives duplicate existing systems, rely on unsupported assumptions, and apply only to one category of lawful home-based businesses. As drafted, the ordinance fails to justify singling out STRs. There are also some problematic provisions in the draft. Section C1 requires registration before occupancy, despite acknowledging the existing prevalence of lawful STRs, effectively forcing operations to cease lawful activities, which is inherent and inconsistent and legally questionable. Section C2 and D4 authorise registration fees without limits or cost justification on top of property and business taxes already paid, while no comparable fee applies to other home businesses in the area. Section F imposes onerous posting requirements based on unsupported assumptions about renters. Section H establishes a punitive enforcement and fine structure, unlike any other for any other business in the area, suggesting revenue generation rather than fines. In closing, for these reasons, I respectfully submit that the ordinance as drafted is legally vulnerable due to lack of rational basis, selective application, and unequal treatment of similarly situated home-based businesses. I urge the council to reconsider favorable application for adoption. Thank you for your time.
Thank you. I have a hand right there.
I'm Sal Marinelli, I live on, Wall Lane. I sit on the planning board and I work on this, I think 2, 3 times. And, I've come to look at this situation and this issue in many different ways. I come down to one basic way now. I believe that short-term rental, the difference between short-term rental and another name is simply a zoning issue. Short-term rental is nothing but a motel. And if we're gonna treat short-term rental with registration, additional fees, etc., I think we're backing ourselves into a corner. I think what happens is, if we're going to have a motel, let's have a motel and have the handicapped taken care of. Let's have fire protection the correct way. Let's have sidewalks the way they're supposed to be. Let's have lighting that's appropriate. Let's have parking that goes with it. I don't think you can have it both ways. I think we have to leave this alone. We have a registration, or we have to look at it in a different way and say, let's have short-term rental as a motel in certain districts. And that's all I have to say. Thank you. I wish that this could be tabled for a while and not voted on, and give us a chance to really look at this and all of us discuss it. Thank you.
Any other hands? Here's one.
I'm Amanda Nickerson Toasty, 253 Great West Road. I'm also a member of the Housing Trust, but I am speaking as an individual this evening. I'm a real estate broker in town. I've heard a lot of commentary about the legality and concern about lawsuits. What I haven't heard from anyone is about the people in Little Compton, our residents. And I can tell you that as a real estate broker here now for over 10 years and on the West Coast, that short-term rentals that are weekends or weeks are not helping our town residents stay. They're not helping our young families move out of their parents into their first apartments. They're preventing families with children from being able to enroll in schools here. And there's a difference between owner occupied short terms where you're renting rooms in your home or an accessory building or a granny pod versus buying homes off of our affordable housing stock, which would be anything less than $700,000, and then locking that up for a few weeks. Those houses are sitting dark, they're not being rented, and we're watching families with children that we're trying to appeal to by building homes for them. But then we're renting everything out from under them. I have some real examples. I had friends that were living in a $1,000 a month cottage. They did all the maintenance for years and years and years. Their landlord passed away. When the next owner took over, their rent was doubled to $2,000 a month for the same cottage that they've done maintenance on for years. They've left town. We looked for 1 year to try to find them another rental that would allow them and their child to stay here so she could go to school. And unfortunately, after going to Tiverton, Westport, East Providence, Portsmouth, they ended up in another rental in another community. These are real people. These are people that also grew up here too and have family and either have lost their homes for one reason or the other, or it was too expensive to stay. So in support of an ordinance verifying septic information, there were some good points about water quality. I can tell you I sell homes that are being marketed one way, and when we pull the DEM permits, I personally, like Tom, I live in a 3-bedroom home that I bought, actually a 2-bedroom home with a septic system that won't be allowed to be repaired. It will need to be replaced. I'm a realtor and I had to comb through paper records to find that info. Homeowners will need to be savvy to go to the database, pull their home, if they're not able to find it by their street address. We'll need to educate them that they should search by plat and lot number, perhaps the builder, perhaps the developer. So there are some things that could be tightened up. It could be as easy as printing the 2-page permit and stapling it to their application to show what their certificate of conformance is. But by registering and creating a database in town, we would then be able to collect data and see what this is doing to our rental inventory and what it's doing to drive the prices of our homes that are being sold for private residences and rentals. There's no silver bullet for this, and if we all work together, it would be great to have rules, regulations, but then some data that we could then dive into and potentially create other ordinances, whether we're easing or creating new. But we have to admit, there's a problem if Newport is outlawing short-term rentals in places.
Thank you. I have a, right, yeah, sir, yeah.
It's Vincent Kennedy, I reside on Bridgeville Road. I would like to question the limit on 30 days, because in my mind, there's no functional difference between 31 or 90 and 30 in terms of what I understand the interest of the town are. As articulated in the proposal. I think the question is more broadly stated about not whether it's a short-term rental, but whether it's a rental period. And I struggle to understand the difference between 30 and 31 days. Thank you.
You. In the back.
Margaret Manning, 81 Flower Road. I just have a clarification. Is this intended to apply to Little Compton's business districts as well?
Would you like to answer that question?
Yes, it's townwide. It's not zoning dependent.
So it's not intended to distinguish between residential use and the business district. So this would limit the ability to conduct business in a business district.
I don't know that I would interpret that from the fact that there's no zoning distinction in it. Tony, do you want to speak to that?
It would not apply to businesses, it's for residential use. If you have a residential use in the commercial business zone, and it's a short-term rental, then it would apply. But not if the let is for a commercial purpose.
Arguably, a short-term rental in the business district would be a commercial use.
Well, that's a debate that's going on right now as to whether or not a short-term rental is considered a commercial use. For zoning purposes.
Yeah, thank you for clarifying.
Thank you. Do I have another hand?
I have to read that letter.
What's that?
I have to read that letter.
See a half a hand. I don't think that's a real hand. Okay. Do you have something you'd like to read?
Yes, I have a letter from Counselor Mataronis.
Do you like a microphone?
Oh, not really. I have been asked to read a letter from Counselor Mataronis, who is away. This is in regards to short-term rental ordinance. Fortunately, I will not be attending tonight's meeting, but I would like my comments read into record. Section D has very excessive requirements that may be hard for some short-term rental owners to comply with. Also, there are 4 affidavits that have to be filed. Will these have to be notarized, and will they be separate statements that have to be documented, or can they be attested to on one document? If the form and affidavits that are going to be required were part of the public hearing, many of these questions would be answered. The yearly registration fee of $250 is very excessive compared to the state fee of $27.50. Is the excessive fee going to be used to hire another employee in the future? Because there are many provisions in this ordinance that are going to need to be conformed by on-site visits and continued updating. In the financial situation the town is coming out of, I do not think this is a proper time for a new hire to add an added cost to the town. I do not believe homestead exemptions apply to short-term rentals, so there will be no discount. We tried to make the homestead exemption ordinance to encourage yearly rentals and not for short-term rentals. What will a parking plan entail? Will it be a diagram, a written plan, or an engineered plan at the cost of the applicant? If the short-term rental has 2 bedrooms with 2 bedrooms in each and a pull-out sofa, who's going to decide how many occupants will be allowed to stay there? Is it 5 people, or if they double up in the beds, is 9 people? The imposition of a $500 a day fine is if warranted, does not comport to any other fine schedule we have in our ordinances now. I think this should be looked at again to align with the fee schedules that we have in our ordinances now. Sincerely, Gary Mataronis, signed today's date.
I'm going to close the public hearing. I thank you, the people that participated. We're going to salute the flag and get out. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Announcements, do we have any? They can come from anywhere in this room. Not seeing any. Approval of minutes.
Motion to approve the minutes of January 8th, unless anyone has any edits. Second.
All in favor?
Aye.
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 Thank you. Department head reports, so anyone like to take one out? I do. The finance director's report. We have John McNamee here. There is copies of this report floating around. Heather, are there somewhere? And we have a in the back, John McNamee, go ahead.
Thank you, Mr. President. So I'm glad to report that the FY 24 audit has been completed as of 3:30 this afternoon. We are waiting for the report from the Department of Revenue. The state about 5 or 6 years ago put to a municipal transparency portal that requires a review by them of a certain report, which is a supplemental schedule to the report. And I met with them this afternoon, and we'll make some changes, and that report should be available at the beginning of next week, which will provide the auditors, and at that point, they can release the report. So I'm hoping that we'll have the final report next week. Once we do have it on the website, so any of you that have trouble sleeping, you can just download this 130-page report, and I can guarantee you a good night's rest. I do have the numbers. It's going to be a little difficult to see the board, but you do have the handout, which is page 4. And you can see that the 24 audited, this is the general fund of the town. And it is showing a use of obviously our accumulated surplus for the FY 24 year of $1,184,291. And leaving us with a fund balance as at the end of the year of 24 of $1,980,967. If we go to the next slide, because I think this is a key slide for the report. We started with last year's 23's audited fund balance was the 3,342,558. I had to restate that fund balance because there was an unrecorded liability of the amounts that were due to the housing trust. They were not reported on the 23 financial statements. So that liability reduced the accumulated fund balance as of 23 to the 3,165,258, which shows in the audit report. The excess of expenses over revenues, as I had indicated, were 1,184,291, leaving us with a fund balance of 1,980,967. Now, the composition of that fund balance, which is key as we're looking at it, because the unassigned fund balance is really what we need to focus in on. So we have three components to that fund balance. We have non-spendable, which basically represents prepaid expenses and inventories that we've already purchased. So we're taking that out of the fund balance basically and saying that's already been purchased. Those monies are certainly non-spendable, I should say. The second one, which is committed, this is the FY25 budget amount that was approved at the FTM for the use of our accumulated surplus. So that's the 1,116,796. So that leaves us with an unassigned fund balance of about 609,126. And that's will show up obviously in the audit report. So that 609,126 is a number that initially we were looking at the end of 25 being somewhere in the neighborhood of about 200,000. So there was a difference there, and that difference was caused by two things. One, there was some unrecorded revenues for housing aid that we were using to offset our debt service. And we had an issue with recording building revenue. So we were outsourcing building permits under OpenGov. So anybody that was getting building permits, et cetera, were making payments to OpenGov, and that was being collected by a third party called Stripe. Stripe was not submitting those funds because we hadn't gotten back to them with a website that they needed to have on there. So from August of 23 to August of 25, we hadn't received any funds. So when we did get those funds in the summer, this past summer, I had to reclass some of those funds to the FY24 revenue. So that really caused a little bit of a difference when what I had anticipated was somewhere around 250,000 up to the 609. So you can see by taking the committed amount, which is the 1,116,796 from FY25, that unassigned fund balance should be something that would be a number that would be similar to what we would be looking at in FY25 on the audit. And I will, once I go through all the 25 numbers, I'll make that calculation as well, which should be shortly as well. And as you know, in FY26, we don't have any use of that accumulated surplus. So we're not going to be impacting that fund balance by any items in FY26 unless we run a deficit, a true deficit, which I'm not anticipating for FY26. So going into the budget season, I think we've got a good idea of what that unassigned fund balance is. And this is something certainly that rating agencies and others that are evaluating our financial stability will be looking at. We also have a fund that's shown separately, which is our capital fund. And in that capital fund is roughly about $600,000. We know that a good portion of that is being committed towards the pickleball. I believe, I don't have the exact number. I think it might be close to 450. There was a couple of $100,000 in that fund that had been approved by the at the financial town meetings, but we hadn't spent that capital. Some of it we had used our opera funds for that capital rather than using our own, capital numbers, so. But, we do have, some fire code issues that we have to deal with on some of the buildings, adjacent buildings. So, some of that money, other than what we have, committed for pickleball, will probably have to be used for that, so. I'm not looking at any additional available fund balance in that capital fund. So that's kind of a Cliff Note version of the audit. But certainly will presentation at the audit at a future meeting.
The council have any questions for the finance director? At this point? So you'll come back at the next meeting, full report of the audit.
Did say future meeting, then.
Future. Does anyone like to ask a question and go to the podium? And a man in the front.
I, the one who's been initiating that audit for quite a few months.
I know you have.
Including the city of Providence. I would like to congratulate you and the town for getting us on the right track, and thank you for your efforts.
Thank you.
You're here.
Thank you. I would add, we're gonna have this, a new business. For. We're gonna go out for an RFP for, fiscal 25 for audit. Contracts is done with our auditor. And I will speak for myself. We're gonna put in that RFP that the 25 audit is done by the top financial meeting on May 19th. So we'd like to deliver 2 audits. This one and one for our top financial meeting. So we're gonna push for that too. But that's later on in the agenda. Any other questions? I have a motion to accept the department head.
So moved. Okay.
All in favor?
Aye.
Thank you. Old business 1. Vote to adopt a proposed short-term rental STR ordinance as written and adopt the statement of purpose as a resolution. Do I have a motion?
I'll make a motion. I'll do 2 motions. First, that we move, I move that we adopt the statement of purpose as a resolution.
Is that a motion? I just don't know why I asked that. I'll second it. Discussion? All in favor? Aye. Opposed? Not hearing any.
You vote.
I'll vote no.
Okay.
I have a 3-1. Thank you.
And then my second motion would be to adopt the short-term rental ordinance as written.
I'll second the motion. So we are in discussion now. And listening to the people talk, I would like to engage the solicitor. There's a lot of legal questions. I scratched them down. Potential litigation. Did you scratch them down too? Would you like to comment on all the legal questions or potential legal pitfalls that may happen if this is adopted?
Well, I can say that I've been involved with the issue now for some time, not just here, but other places. That's the first thing. So what a town can't do is prohibit the use of short-term rentals in the town. That's by state statute. The next thing that a town can't do is have a licensing scheme for short-term rentals. That is not authorized by state law. What a town can do is regulate short-term rentals by the zoning ordinance. And that's what Newport does. There's been a series of cases in Superior Court. I expect that at some point the Supreme Court will weigh in on it. But so far, municipalities have been successful in essentially regulating short-term rentals in a zoning ordinance. That's not something that you've chosen to do. Usually the restrictions are greater there. That's what Newport's doing, by the way. The final thing is, 14 communities in the state are enacting registration ordinances similar to this one for the purposes that have been set forth in your statement of purpose for that. The main argument that I heard is that the registration fee that you have at $250 doesn't bear a rational relationship to what the town has to do in order to administer this registration ordinance if you pass it. There was a case a few years ago, the Rhode Island Builders Association sued just about every city and town in the state, and unfortunately, I was involved in that for two communities. One of the communities I represented was successful in a motion to dismiss, and unfortunately, one wasn't. And the court found that there was no rational relationship between what they were charging for their building permit fees and what the town had to do in order to administer building permits. In this instance, the arguments have been that this is a robust registration ordinance, which it is, by the way, if you take a look in comparisons with it, because of the things that need to be done by the town in order to administer this case based on this ordinance, based on that prior case and the ruling in the court on that. The $250 actually does bear a rational relationship between what the town has to do and to administer this registration ordinance and the fee that's charged. That's my interpretation of this based on my experience in that prior case. The next question is whether or not there is an equal protection argument here. And I don't see that happening, and I'll tell you why. The state makes a distinction between short-term rentals and regular rentals. And to answer Mr. Kennedy's question, that 30-day definition comes from the state. And it's not, it's actually peppered through the state statutes, including the taxation of it, because as one of the speakers pointed out, there is short-term rentals are considered to be hotels, and they have the hotel tax. That's where the 30 days come from. And in fact, in one of the circulars from the Division of Taxation, they make the statement that if, and this is a direct one, if someone rents a house in Barrington in the month of June for the golf tournament at the Rhode Island Country Club, they don't have to pay. Right? Now, I disagree with that because that's a 30-day month. It's not a 30-day month. If it was July, it'd be a different story. But that's the cutoff. And I think that's what's used here. Typically, short-term rentals don't go that far, but many do. So I think that's where that comes from. Based upon that, based upon the cases that have come out in regard to short-term rentals, in some communities, it's a very big issue. Newport and Narragansett are the two leading ones, but Providence also has some issues too. I think that this ordinance would survive any legal challenges. And in fact, so far, none of the registration ordinances have been successfully overturned in court. Narragansett went a bit beyond registration, and they have lost actually 2 or 3 lawsuits along the way, but not for an ordinance of this nature.
So just to entertain me just a little bit longer and I'll stop. The planning board has had 2 drafts of this. And this committee, which I was not on, has taken those 2 drafts and come out with this. And from what I can see, it's quite a watered down ordinance from what was given to them. Am I correct in saying that? Am I reading it right?
I always hesitate to use the term watered down.
It's not a great word, but not as it was more enforceable on the other 2 drafts than it is on this one.
Well, I'm going to say this. These are policy considerations. And the question always for the lawyer is whether or not an ordinance that is passed would survive a lawsuit. And on this one, I think it would.
Good enough. Maybe we can get into that later. There's a couple other things that I wrote down. The state registration. Everyone's talking about the state registration, right? I don't know the state registration from Adam, okay? But from what I hear is it's awful. It's not online. The information is not there. Is this true? Do you know that to be true?
Well, I think it's two different schemes. The state statute that we keep talking about that allows for short-term rentals and says that communities cannot prohibit short-term rentals in the community. That was a law that came in with the support of these hosting platforms. And the reason that you see these registration ordinances comes from the experience of many communities that oftentimes, if there are issues, those issues are not handled by the state, but instead have to be handled by the local community. And that's why you come in with this registration ordinance. And also to make sure that these short-term rentals are safe for the people that do rent from them. So there are some things that the local community has to do that the state would never do in the registration. And that's why you have these requirements for someone that you can get a hold of within 2 hours and things of that nature. That's why you have that. There is a local angle to having short-term rentals in the community, and that's the basis for these type of registration ordinances. So the town knows where they are, and there can be responses if there's issues.
Right, right. So, I mean, it just seems to me that any issue, if we don't have the proper data, that we need to have the proper data. And what I'm understanding is we can't get that from the state. That's what I'm hearing. I'll just move on so other people can talk. The issue that is gonna burden employees at the town, my understanding, from what I've heard, it's not going to be. It's gonna be net zero. We're not gonna have to hire 10 people to go run around and do these things and burden people. I'll let other people talk about that. And I think the last thing is if people here have a guest house or an ADU or an STR that they've had for years, right? 40 years, 50 years, and people are, living in it, and that's what we do here in Little Compton. Are they gonna be grandfathered in? They're gonna be safe, I would imagine. Is there a mechanism to protect those people?
Well, there's two things. If someone has a guest house that they've been using as a short-term rental prior to the enactment of the ordinance, that would be considered a so-called grandfathered or grandmothered use, as the case may be. That's the first thing. The second thing is you do have a provision in the ordinance, I think it's H7, that allows for the town council to make exceptions for matters of that nature.
So if someone's had one for years and the families are there and they're all living in the bunk beds and everybody's having a great time for 40 years and they say, what's going on with this registry? You just come to the council and say, sure, you've been doing it for this long. That's the fabric of our community. You can keep doing it. Is that right? Okay. So there's no boogeyman there. People can have their ADUs and their STRs that they've had for years and years and decades and not have an issue. That's how I understand it.
You're prohibited from renting to ghosts.
No ghosts.
STRs.
So we just wanted to get that out. That's someone that's trying to learn this. I know Victoria is probably knows more about this than anyone in this room. If you have anything to add, or obviously the council.
I was just going to add on the state registry piece that there is online access to the state registration. It's very limited in terms of the information that you can glean from it. But importantly for our work, the site has been down since November and I don't know when it's coming back up. So we've been able to get nothing from it. So that's just a little insight into the state registry.
Anything else from the council on this before we vote?
The manner in which this has been presented to me solves a problem that I don't yet understand an ordinance as being the method by which it will be solved. I am reluctant in every case to establish as a group of 5 people direction to the rest of the people in town, for this is how you'll live your life. Unless there's a value. And it sounds like there are some valuable data that may come from this. I would be cautious that this does not become, and I'm not sure how to stop that, because once a public body gets a taste of something that seems to be working right, there tends to be an attitude of, let's create another thing to tell people how they need to live a different part of their life, which is, to me, an antithetical to our town's way of life. So my general approach to these kinds of things is to say they are unnecessary. I am persuaded, however, that in this particular case, were we to find that the data that we accumulate might be useful in establishing a more comprehensive and perhaps a less invasive method of control, I'd be for that. So I expect to reluctantly vote in favor of this, but I've got to say, I am not generally excited about telling citizens of the town what they should do with the property they own, when the benefit that's gained does not seem to be commensurate with what other cities and towns are trying to preclude. And that is wild extravaganzas in the middle of residential zones. I don't believe those are happening now. I don't believe this will change that. But what it may do is enable us to have a better idea of what we've got where, and give people the opportunity to speak back to us. We think you've made a mistake in this area or that area. I'm happy to hear those kinds of feedback. I don't hear it this evening. I don't hear people saying, you're out of your mind doing this thing. You ought to stop doing it and turn and go the other way. But there's been an awful lot of very considered comments that have come from the public tonight that I think are very important for our future.
Anyone else on the council? Anyone else? Do I have a motion on the floor?
Two.
A motion and a second. All in favor? Aye. Any opposed?
I will abstain from voting.
Have an abstention. Thank you. Old business 2, remove Brendan Hayes from the ad hoc committee for the housing opportunities and municipal strategies. Brendan was very enthusiastic about being on this, but he could not do it. It was work related, and I'm going to miss him on it. Do I have a motion?
So moved.
I'll second it. All in favor?
Aye.
Thank you. And we won't leave that seat cold. Vote to seat Christopher Killenberg on ad hoc committee for housing opportunities and municipal strategies. Do I have a motion? I'll second it. All in favor?
Aye.
Thank you. 4, update regarding homestead tax exemption. I have Councilor Talbot written on here. Is that the right person?
That's me. Tuesday, Representative McGaugh brought our proposed homestead tax exemption legislation before the House Committee on Municipal Government and Housing. A few of us went up to the State House in support. Anya, our town administrator, Tony, our town solicitor, Jim Locke from the Homestead Tax Exemption Working Group, and myself. The meeting went very well, sort of short and sweet. A few questions that Jim Locke helpfully was able to answer. And the next steps are for Representative McGaugh to work with the committee members to encourage them to pass it out of committee. Once it's passed out, it will go to the House floor for a vote. Senator DePalma has introduced a companion bill in the Senate, which will go through a similar process, and we will keep you posted.
I want to thank everybody for going up there. Tony, I know you get stuck in traffic. Anya, thank you for going up there. Victoria and Jim Block. Another trip by Little Compton to the State House. So we'll have to go up again on the Senate side. So you all have to go back. So I appreciate that. Thank you. There's no vote there. Thank you for that update. 5, receive a letter of recommendation from DPW Director Ted Bonning to hire Ian Burke, temporary seasonal maintenance labor position for up to 2 weeks. Anya, would you just like to?
12.
What I said?
2.
12.
12 weeks. Anya, would you just like to put a little transparency on this one and why we're doing this?
Sure. Ted, the Public Works Director, could not be here tonight, so I'm reporting on his behalf. We advertised this position. We had 3 candidates apply. Those candidates were interviewed by Ted and the foreman of his crew, and then Ted came to me with a readout and recommendation all three candidates were highly qualified. Ted is recommending that we make an offer to Ian Burke. The agenda item says for up to 12 weeks. I would ask that you possibly extend that or leave it unspecified, just because we don't know how long the employee who's going out on leave will be out, and it may be longer than that. Otherwise, we can come back to you and ask for authorization to continue the employment. Ted gave you a memo explaining his rationale for making the offer to Mr. Burke. To answer any questions.
I'm gonna go with the option and keep it at 12 weeks and you can come back.
I'll make the motion to accept the recommendation of the DPW director to hire Ian Burke. I'll second that motion.
Any further discussion? All in favor?
Aye.
Aye. Thank you, Anya.
Thank you.
This is one notice of intention for the town vacancy of the position of deputy town clerk. I have Heather written down for this one.
This is just my notice to you for approval to post for the vacant deputy position per the municipal union contract requirements.
All set. We don't need a vote for this, Heather? We do, okay.
I'll make a motion to authorize the town clerk to use this notice. Second.
All in favor?
Aye.
Thank you. Business 2, request from the Parents Helping Students Organization, SO. Post-prom committee seeking a donation of this year's class of 2026 post-prom celebration. I make a motion of $200 to the PHSO.
Second. From the
Contingency fund. Sorry, thank you.
Bob?
All in favor?
Aye.
Thank you. 3, receive a request from the Wildlife Clinic of Rhode Island to the Budget Committee, a stroke in the amount of $544. I'll accept a motion and put on file.
Second.
All in favor?
Aye.
Aye, thank you. A request from the Finance Director to advertise for proposals, professional audit services, and agreed upon procedure services on a 3-year period. Proposal number 2026-01. I had referenced this before. Our contract with our current auditor has expired. We need to go out for an RFP for a new auditor. And in that RFP, we're going to put some language in there that we want our 25 audit by May 19th. And I'm hopeful we're going to have that. Mr. McAfee, go ahead. Did you have anything to say?
Yeah, we will have a draft by financial time. Final report will be in the document will be by the 30th. We will have that final report. I don't mean to contradict you, but I just.
No, that's fine. Do I have a motion? I'll make a motion to request to advertise for our auditor.
I move to approve the finance director's advertising for proposals.
I'll second your motion.
Oh.
Sorry about that. All in favor?
Aye.
John, would you like to leave?
Am I gonna miss the adjournment?
Go get the draft.
We have a lot of letters of interest for our board, so let's see if I can get this right on the first time. Received letters of interest for 3 Harbor Commission members, Fishermen Association, Recreation and Boater, Yacht Club representative, 3-year terms. I want to make a motion. I'm going to put them all in one.
Yep.
Ben Gauthier, Ian Parente, and Mark Manning. Do I have a second?
Second.
All in favor?
Aye.
Thank you for those folks. Received letters of interest for 3 planning board members. We have 3 up, and as my recollection, we have 5. Letters of interest, is that right, or is it 6?
What we had.
5.
Could you name those 5 people?
I have Allison Sampson, Ginny Greenwood, Val Marinosi, Carl Friedman, and David Sloan.
Thank you. I would ask you to make some interview time for these people, and we'll talk about that as a council in a few minutes. Thank you. We good? 7, receive letters of interest for 2 positions on the Recreation Committee. The 3-year terms. And we have 5 members. Bill Terrio.
Four.
We got 5. We'll see who wins this one. We have Bill Terrio, Mike Rocha, Andrew Marion, Dave McGregor. 4, you win. Yeah, I counted Dave twice. I would like to make a motion to appoint David McGregor, who is an icon here, and he is invaluable on there, and I would not drag him in for an interview. Do I have a motion for Dave, Mr. Mac McGregor? I think I made it. Do I have a second?
I'll second it.
All in favor?
Aye.
The other 3, could you please set up interviews for those 3, please? Receive letters of interest from the tree warden. We have 1. Jason Burchett, I'm happy to make that motion. To second.
Second.
All in favor?
Aye.
Thank you, Mr. Burchett. Receive letters of interest for housing trust members, 5-year term. So long term. Heather, I think I have 3.
You have
I have
4. Oh, excuse me, I'm sorry, 3.
I win that one. It's tied now. Sue Boddington, Sal Marinosi. And I have a 3rd, is a Kilmer, is that the last name, right?
Don Kilmer.
Okay, so I'm gonna make a motion to appoint Sue Boddington and Sal Marinosi to the Housing Trust. Do I have a second?
I'll second that.
Any discussion? All in favor?
Aye.
Thank you. Receive letters of interest from the Board of Canvassers. Member 6-year term. And how that worked is the town chairman for the Democratic Party sends a list to the town council president, as does the town Republican chair. I received those lists and I get to pick one. And they must have wrote that, and I don't know what year they wrote it, but they wrote it. So I'm going to make a motion for Karen Kelly. Do I have a second?
Second.
Any further discussion? All in favor?
Aye.
11, receive letters of interest for 2 Historical Preservation Advisory Committee members, 3-year term. We have 2. I'll make a motion for Jan Williams and Leslie Fox.
I'll second it.
Any more discussion? All in favor?
Aye.
Thank you both for that. Communications. Letter from the Harbor Commission for a draft outline plan with status update for the town dark parking area. Do we need to, Ben, do you need to speak on this? I know we've made a motion to already authorize this in a prior meeting. I don't know if we have it on the board.
No.
We don't. Good.
The town is proceeding with its CRFC application through Bill Smith's process. We did a draft of the outline of the parking lot consistent with what we showed you last time. Earlier in the year, last year, there was a older CRFC map that was shown by Scott Brown. So I wanted to look at the CRFC to see if that map by any more restrictive conditions that was put on CRFC website currently. Anthony Sariad, CRMC came back to us this week and said, no, the website map is the governing map, and the earlier map is poses no restrictions beyond what is in the draft that he had from Bill Smith. So Bill's on vacation this week, and he gets back next week. I'll review that draft and we'll double check our masters on the internal arrangements and with chief as well. We'll go with an application to the CRC. A couple of weeks in the process. Solid application in the town. We also asked Bill to focus on the parking lot because of the pressure that we're going to have schedule wise with squid fishing starting up in April. He still has in queue the 2 lots along the beach. We're going to take the boat on Bull Barry to protect the people from but those will come in the weeks to come. We really want to prepare basically the parking lot application.
Thank you. I think all I need to do is accept this communication. Have a motion to accept?
So moved.
I'll second it. All in favor?
Aye.
Aye. Consent?
Motion to place the consent calendar on file.
Second.
All in favor? Aye. Before we, payment of bills?
Motion to pay the bills.
Second.
All in favor?
Aye.
Before we adjourn, I just want to talk about when we can schedule interviews, but I am gonna adjourn, so we'll talk about it after we adjourn. Motion to adjourn? Oh, I have a,
You want me to mention the transfer station?
oh, sure, go ahead. We have a public announcement. This is fun. Go ahead.
Due to the potential of a major storm on Sunday, it is possible that the transfer station will be closed on Monday. Just want to let folks know. The guys will be out plowing all night if we have such an event. Thanks.
Yeah, motion to adjourn.
So moved.
Second? Favor?
Right?